Hello, and welcome to Connected With Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. I'm Tom Evans, a private equity M&A partner in Latham Watkins' London office, and today I'm joined by fellow colleagues Jana, Dammann, Chapto, and Phillip Studt from our Hamburg and Brussels offices, who lead our FDI team in Europe. In this episode, we'll be discussing key regulatory and legal developments in FDI investment and the implications for business. Investment screening, also known as foreign direct investment or FDI screening, is a highly dynamic area of law. For a long time now, it's not just been about screening defence acquisitions. Rather, target companies in the software, healthcare or food sectors that are supposedly unsuspicious in terms of security law can now also trigger investment control procedures that screen transactions based on particular potential national security concerns. From my experience, that's included transactions in the blood plasma and the relatively benign infrastructure assets. Jana, Phillip, welcome and thank you for being here.
Thank you for having us, Tom. Hello.
Thanks. Hi, everyone.
Let's start with an overview of what we're seeing in this space. From my perspective as an M&A lawyer, it seems that the number of FDI notifications for transactions has increased, and it seems that almost every country now has its own regime, and where regimes have been in place, additional thresholds have been introduced in some cases. Generally speaking, what are we seeing in terms of the number of jurisdictions conducting reviews, and why is it happening?
Right. So if you look at global regimes that we have in place today, there are more than 50 jurisdictions that actively screen FDI. And if we look at the European Union, there's only less than a handful of member states today who don't either have regimes in place already or regimes in the making. So we really do see an uptick in FDI enforcement. Luxembourg has been the latest edition. They enacted a new regime September 1st. And if you look at the numbers, and there are statistics out for last year, 2022, there have been more than 1,500 applications for FDI reviews in the European Union alone. And to break that down a little, of those 1,500 applications, around 30% have been screened for potential national security concerns, but only 1% of those has been blocked. But there have also been 23% of those being cleared subject to remedies. So we do see an uptick in interventions in the FDI space. So that's a development driven by the economic effects of COVID-19, heightened geopolitical tensions, and also increased protectionism. And Phillip, I think that's something we see also in the merger control space.
Yeah, so going beyond the FDI space, there's additional requirements now coming in with the new EU merger control forms, which are being sold by the Commission as sort of a simplification of the process because they're making it a bit of a ticking the box exercise. But hidden behind that is actually our additional disclosure requirements when it comes to minority stakes, cross ownerships, cross shareholding, or cross directorships and expansion plans. All of these are things that are not easily providable by many parties, and especially in non-problematic cases, it's something that increases the burden on the parties. And beyond the traditional merger control regimes that people are at least fairly familiar with, you have the new FSR regulation, which is already in force but will be applied as of October. All of these are things that in the past weren't often disclosed, and it just leads to a picture of you need to be prepared, you need to plan in enough time because this is a burdensome process and we will try and make it as easy as possible, but parties need to be prepared for this.
So it sounds like a lot more filings are required now with a lot more disclosures. What impact is that having on the time it's taking for transactions to be approved?
Yeah, in terms of timeline, I think it's important to note, first of all, that FDI reviews take longer than merger control on average, even if we are talking about no issue cases. So phase one review periods, they are at least 2 months. And then depending on the jurisdiction we are talking about, it can take longer. And then if you have a problematic case that moves into phase 2, then that's really something that can impact timing, because in theory, like in Germany or the UK, phase 2 processes, they have a timeline as well. But there are a lot of stop the clocks in situations where the government asks questions or where you get into remedy discussions. So we have seen cases that lasted 6 months plus or even a year if we are talking serious remedies.
Wow. And I also heard a new expression recently called ITAR infection. What's that?
So yeah, you're absolutely correct. This is a new term, ITAR infection. ITAR, for those who are not familiar with this term, meaning the International Traffic in Arms Regulation, which is essentially the US government's export control rules that apply to any goods being exported from the US and that are classified as sensitive from multiple angles. This is something that has actually come up more often recently and is a serious concern on the side of EU governments in particular. And what it refers to is the fact that if you have a US investor in particular acquiring a company in the EU, and the company in the EU produces goods that are then sold to EU governments and especially militaries, and the US investor, on the other hand, has similar products that might and technology that might then be mingled or commingled, suddenly that means the goods being produced by the EU companies will also be subject to export control rules in the US, meaning that European military forces, every time they go abroad and want to use these particular technologies or goods on the battlefields or in any sort of foreign circumstances, they will need an authorization from the US government, which is something they are obviously not keen to accept. And that leads to parties having to come up with solutions here, either by promising to keep technology separate, and where this is not easily doable or where governments are suspicious of this being implementable, they will ask for stringent technology control plans where parties have to make sure that these technologies really remain separate. And that can be quite burdensome because it's something that you will have to keep on implementing in basically perpetuity until you get authorization to stop doing it again.
In terms of FDI generally, I guess with antitrust, we can do a jurisdictional analysis based on turnover and horizontal and vertical overlaps. And so the information is largely known by the parties before they submit it to the regulator. With FDI, that's not the case. There's always going to be a lacuna, some information which isn't known because it is sensitive and may not be disclosed by the government to any parties. For antitrust, it's quite common to put in a provision in the contract which is what's known as a hell or high water undertaking. That is, the buyer typically is obliged, come hell or high water, to close the transaction and to give to the antitrust regulator whatever undertakings might be required. With it not being as certain for FDI, what have you seen under contracts for the allocation of the FDI risk between buyers and sellers?
It's actually interesting. It's kind of weird because, as you correctly say, there's a lot more unknowns here in the FDI space versus the antitrust space. So one would assume that companies are less willing to accept such hell or high water clauses because they wouldn't know what they might be running into. However, given that in FDI, these regimes are a bit younger and authorities tend to accept what is called behavioral remedies rather than structural remedies, i.e. they don't have to divest and sell off parts of the businesses. They're typically only required to either maintain certain supply relationships, keep certain IP separate, or similar types of commitments. These have in the past not been considered as burdensome, so companies and investors are willing to take that risk. However, we're seeing a slow shift now because there is a realization that because a lot of these commitments are essentially in perpetuity until you're selling the business or until you can, in a new application, convince the government to drop them again, these create a lot of cost on the part of the company and then indirectly the investor. I mean, looking at the technology plans we just discussed with the ITAR infection, that is something to consider. And if as a strategic investor, you're made aware of that risk early on, you might now be less willing to accept the hell or high water and are more sensitive to that fact.
I think that's right, Philip. As you said, because FDI is relatively new and so far many cases just get cleared without any issues. It's not been that much of a concern to discuss in the context of hell or high water, but going forward and with more and more cases accumulating, being cleared, subject to remedies, or even blocked, I think it's something that deal teams are going to become more and more aware of, and we're going to see FDI being discussed more in that context.
Interesting. And so yet another development in this space, we talked about ITAR infection earlier, where we have non-US governments concerned that technologies will be subject to the ITAR regime in the US. And in the US itself, the topic of outbound investment control has been discussed for some time. Such a restriction, I guess, would mean that capital flows from the US to other countries could be subject to a screening process, or what some people have called reverse CFIUS. Is that also a concern in the European Union, particularly, say, in the context of semiconductors?
It is actually. So there's an initiative going on now in the EU where basically the European Commission wants to discuss with the member states whether outbound investment control is something that should be implemented. If something like that will come into force, it's going to be at the European level. So differently from classic FDI as we know it now, it's not going to be something that the member states introduce, but it would be something being introduced on a European level. How quickly that will go, I don't know. I think they just started discussions about that and they might come up with an initiative by the end of the year. But I really think the challenge here is to identify the risks they want to address with outbound investment, risks that are not already covered by, let's say, export control, because I think a lot of the concerns like investment into technologies is already something that can be addressed with existing regulations. So it's going to be about striking the balance between addressing risks and not introducing further regulatory burdens on companies.
And an area where semiconductors in particular are most interesting for regulators is in the context of artificial intelligence. And there's been uneven developments around the globe and responses by regulators to artificial intelligence and what it means, what should be regulated and how it should be allowed to flow across borders. How are you seeing that reflected from a FDI perspective, Philip?
So AI technologies, while it is in many respects a new topic, is something that has been covered by FDI regimes typically for a while. Means for some of these regimes that have only been enforced for 2 to 5 years, so not that long, it has been a key focus area for FDI. The problem that we and companies are facing, as you say, is that the regulation and the definitions around AI are very uneven, which means that some regimes will simply refer to any solutions, technologies in AI without further defining what this AI is supposed to be doing, what types of activities within AI are really relevant and important to a particular government. And some will be rather technical. So giving an example, Germany and the UK have taken a bit of a more technical approach. So you get a bit of a better sense of what types of AI technologies and applications the government is trying to catch and screen here, while other governments looking at Austria, Belgium, or even Italy have applied very, very broad definitions, which means that in a world where AI is expanding and AI applications are found in almost any software and tech company in some form or shape, you have to notify the most sometimes ridiculous or benign types of transactions that will end up being cleared quickly, but it's an additional hurdle. And you will only really know what type of AI application the government is really trying to target when you are in the procedure.
So ITAR infection, reverse CFIUS, artificial intelligence and uneven approaches to those. What do deal makers do from here? What do deal makers need to be aware of, and how do we prepare for future deals?
First and foremost, I would say time is of the essence. So you need to be aware of FDI in your dealings, in your transactions. And you need to make sure that you kick off the analysis of potential filing requirements early on. Because differently from merger control, it's not always easy to identify those filing requirements because we do not look at revenue thresholds that are pretty easy to identify like we do in merger control. We do need to look at what the target company actually does, the type of business in every jurisdiction where it is present. So this takes time and needs to be addressed early on in the process because otherwise you get into issues timing-wise. And you cannot just start that a week before signing, which is something that we do see on occasion. So make sure that you are aware of all formal filing requirements because that then also impacts the timeline of your deals, the long stop date that you may set.
Yeah, one of the aspects that impacts the timeline to a great extent is also information and the fact that we were talking about the number of filings you might now have. While each of the filings separately might only be, a month or 2 months of review, if you're facing 10 or 15 filings, the amount of information you have to provide is oftentimes quite staggering. So you need to be organized. And importantly, you now need to also consider what are the dynamics of the deal. Are you a financial investor? Are you a strategic investor? Where is your money coming from? Who will you have to disclose in terms of origin of the money or even identity of the companies giving the money and investing? And that's something you have to organize in advance, and that will impact not only the timing, but even the substantive review by the authorities. And that is something you need to consider early on. And on the other hand, as we discussed, while remedies still are typically behavioral, it's important to consider the actual risk on each transaction, that they will have an impact on your business going forward and how significant that impact is. It's not always as easy to calculate as a divestiture because you have a business value that can be fixed to that business that you're selling. Here, it's more of a long-term cost, and that needs to be taken into account.
Well, thank you very much. Your insights here have proved invaluable. Thanks for joining us today.
Thanks for having us, Tom.
Thank you, Tom. That was very interesting.
And thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or wherever else you get your podcasts. And you can download our FDI mobile app via the usual app stores for summaries of key aspects of CFIUS and other FDI regimes around the world. If you'd like more information about the topics in this podcast, please email us from the links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 1271 Avenue of the Americas, New York, 10020. Phone number 1-212-906-1200.